Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in my previous presentation we learned that administration has lot of powers, or it does lot of actions or functions, and how to control them. Now there can be an independent question on judicial review or remedies available against the administrative functions, but what I thought is I will also discuss the controls available with the parliamentary with regards to administrative functions and then give a full focus presentation on judicial review. So my first slide will discuss on parliamentary controls available against the administrative functions, and then I'm completely switching to the remedies available or judicial reviews available against the administrative functions so that you have a comprehensive answer. With that, I'm getting into my first slide, which is about parliamentary control over administrative functions. Most of the administrative functions are controlled by two important bodies, one being president or governor, second being the ministries of the government. Now, both of them are controlled by parliament in many ways. For example, president is appointed by the parliament and he can be removed through impeachment by the parliament, and whatever ordinance he is bringing, that needs to be ratified by both the houses of parliament, and president is advised by parliament. That way there is a lot of control available with parliament when it comes to administrative functions. On the other hand, the ministries, they need to report to the parliament. Parliament can ask questions to them. The salaries of ministries is fixed by the parliament. That way there is a lot of controls available with the parliament, and I have brought 7 points which I have already explained. You can take the screenshot for more notes. As I said, judicial controls are the most important controls available against the administrative functions, and I have 7 important those controls. And if you write those 7 side headings itself, you are going to get some marks. So try remember this slide as much as possible, and they're all commonly heard concepts, so you can remember that. The first being constitutional control available against the administrative functions. Then we are discussing the equitable remedies available against the administrative functions. I'm also discussing in briefly the common laws, that is the power of state to do trade or contracts and the tortious act by the state. Then we have ombudsman, which is all about Lokpal and Lokayukta, and we have public interest litigation, and then the statutory remedies available, and lastly the self-help. These are the 7 important judicial controls available to control the administrative functions, and we are going to discuss them one by one. When it comes to the constitutional controls of administrative functions, you need to remember few important articles, starting from Article 13, then Article 32, then Article 132 to 135, then Article 136 and 226 and 227. Now, Article 13 is very clear. Any law which is made by any body, if it is against the constitution or if it is not as required by the constitution, then that is void. Article 32 is all about writs, which is again discussed under 226 article, which is the rights of the High Court. Now, writs, I have an independent presentation, so you can go through that presentation to understand the writ concept as well as the several case laws that I have quoted. Now, one can approach Supreme Court under appeals from Article 132 to 135 against any administrative functions, and there is opportunity to approach the Supreme Court under Article 136 also with the special leave jurisdiction. And there I have 2 important case laws. One, Sharma versus State Bank of India, where it was held that Supreme Court power under Article 136 is wider than the High Court power under Article 226. It can extend to the question of facts also. Now, the second important case which is discussing on saving time, money and other stuff, which is Central Coal Fields versus Jaiswal Coal Company, where Supreme Court can adopt quick procedure to achieve quick justice and save time and money. Now, the last article that you can mention is supervisory jurisdiction of High Court under Article 227. Under all these constitutional provisions, one can fight against the administrative functions if there is anything gone wrong. That is about constitutional controls which are available under judicial review. With that, let's move on. The second important remedy that is available through judicial remedy against the administrative functions is equitable remedies. There are 2 types of equitable remedies, first being declaratory remedy and the second one is injunction. Declaratory remedy is a action by the judiciary to declare what are the rights and obligation of both the parties, and most of the time it is not in favor of anyone or it is not against anyone. The second category is injunction. Injunction is basically if you are planning to do something or if you are already doing something, judiciary may ask you to stop that or not to do that, which is called injunction. Now there are four important types of injunction, that is temporary, permanent, positive and negative. What are temporary injunction? If there is a fight between A and B or there is a dispute between A and B for a particular land, the court may give a temporary injunction saying that till the time the dispute is over, neither A nor B can sell that land. That is temporary injunction. What is permanent injunction? Once the case is over, A might have won the dispute. In that case, court can order to B that he cannot sell the land. That is permanent injunction. Positive injunction is about doing something and negative injunction is guiding not to do something. These are the major types of injunction that you can bring in your answer sheet. Now this one slide has 5 other judicial reviews available against administrative functions. Why I have brought all of them in one slide? Because mostly I have independent videos on them or I am going to make independent videos on them. Why? Because they can be an independent question. Now for example, the point number 3, which is on common laws, which is discussing about state liability for contract, which is discussed under Article 299, or the tortious liability, which is discussed under Article 300, is an independent question. So I have discussed that topic, which is available in my playlist Administrative Law. Please go through that presentation because I have beautiful case laws for that. Now, fourth point is Ombudsman, for which I am going to make an independent video, which is all about Lokpal and Lokayukta. I am going to give the timeline and the entire story behind Ombudsman. The fifth point is public interest litigation, for which I have already made a beautiful video with case laws, which is available in my administrative law playlist. The sixth point, which discusses about 3 important statutory remedies under civil suits, appeals to courts and appeals to tribunals. I am going to make an independent video on tribunals. As far as civil suits, you can refer section 9 of Code of Civil Procedure, which gives rights to the civil court to entertain suits under civil nature. Now the 7th point is self-help. How can a person help himself against the administrative functions is discussed under self-help. This is a small point which I am discussing with the case law of Stroud versus Bradbury. What happened here? There was a law by name Public Health Act 1936, under which if any sanitary inspector, if he is going for inspection for any private places, he had to give notice to such person. However, here the sanitary inspector failed to give notice to one such person and entered his private place, that means home or something, but the person didn't allow such officer to enter the place, saying that he has not given any notice. The court also held that it was the responsibility of the sanitary officer to give notice before entering such places, and by self-help the person has done a right job, so the case went in favor of such private person. That is all about the judicial reviews available against administrative functions, and I repeat, there can be an independent question on judicial reviews or remedies available against administrative functions, and this should be your answer. That means the previous 2 slides and these 5 points where you have to refer my other videos also, they will be the material for your answer on this particular answer, as well as they can be an independent question also. That brings an end to this particular video, and there is a lot of request for videos in Hindi. My Hindi is not that good, but I am thinking on that. Sometime I will come definitely on Hindi videos also on my other channel, Kachi Hindi Pakki Law. I have got a lot of support from you guys. Thank you so much for that. I hope you have already subscribed my channel. If not, this is your time to subscribe my channel. Please like, share and comment my videos. All the very best for your exams, and thank you so much for watching me.